Say that again, the defendant muttered under his breath, leaning forward just enough for the witness to hear. I dare you. The courtroom microphone caught it. Not fully, but enough. The witness froze mid-sentence. The prosecutor stopped speaking, and the judge slowly lifted his eyes from the file in front of him. What did you just say, Mr. Kane? The judge asked calmly. Daniel Kane straightened in his chair, adjusting the sleeves of his tailored suit as if nothing had happened. I said nothing, Your Honor. The witness swallowed hard. The prosecutor stepped forward. Your Honor, the defendant just attempted to intimidate the witness. Kane's jaw tightened. That's ridiculous. The judge leaned slightly forward. This court will not tolerate interference, he said evenly. Mr. Kane, you will remain silent unless addressed. Kane gave a thin smile. Of course. But his eyes remained locked on the witness. The room felt smaller now. The witness, a former associate turned cooperating party, shifted in the stand. His hands trembled slightly as he gripped the edges of the wood. Continue, the judge instructed. The witness cleared his throat. As I was saying, Mr. Kane instructed us to reroute the contracts through shell vendors. Kane exhaled sharply. The prosecutor continued. And what would happen if someone refused? The witness hesitated. Kane leaned back, slow and deliberate. The pause stretched. The judge noticed. You are under oath, the judge reminded. The witness nodded quickly. He would make sure you were finished. Professionally. A faint murmur. Kane laughed softly. Finished? That's dramatic. The judge's tone sharpened. One more interruption, and I will hold you in contempt. Kane raised his hand slightly. I'm simply listening. But he wasn't. He was watching, studying the witness the way a predator studies distance. The prosecutor moved closer. Did you feel threatened? The witness didn't answer immediately. Kane leaned forward again. This time, it wasn't a whisper. It was quiet, but deliberate. You know what happens to liars. The courtroom went still. The witness flinched, and this time there was no ambiguity. The judge's hand struck the bench. Enough. The sound echoed like a gunshot. Mr. Kane, stand. Kane's smile faded. Slowly, he rose. You will explain. The judge said, voice colder now, why this court should not interpret that statement as direct witness intimidation. Kane's composure wavered, but only slightly. I was referring to the legal consequences of perjury. The prosecutor shook her head immediately. That is not how it was delivered. The judge's eyes did not leave Kane's face. You are already facing sentencing on multiple counts of organized fraud and coercion, the judge said. And now, in open court, you test this bench? Kane inhaled slowly. Your Honor, emotions are high. The judge leaned forward further. Not on my side. Silence again. The judge turned to the witness. Are you feeling threatened at this moment? The witness didn't look at Kane. Yes. That single word shifted the energy entirely. The prosecutor stepped in. Your Honor, we move to request immediate protective enforcement in formal consideration of this intimidation attempt. Kane's attorney shot to his feet. Your Honor, this is being exaggerated. There was no explicit threat. The judge raised a hand. Sit down. The attorney sat. The judge looked directly at Kane. You were warned, he said quietly. At the start of these proceedings. Kane didn't speak now. The judge continued. This court has tolerated your posture. your interruptions, and your visible attempts to unsettle testimony. A pause. Asterisk, but intimidation of a sworn witness crosses a line. Kane's mask began to crack. It was a statement, he said tightly. It was leverage. The judge corrected. The word hit hard, because everyone in that courtroom knew Daniel. Kane's reputation. Leverage was his weapon of choice. The prosecutor stepped forward again. For years, witnesses withdrew complaints shortly after similar statements. The judge nodded slowly. I am aware. Kane's breathing changed, slightly heavier. The judge folded his hands. Mr. Kane, you seem to believe that power extends beyond these walls. Asterisk. Kane stared straight ahead. You've operated through pressure, the judge continued. Through? Implied consequence. Kane said nothing. The judge's tone hardened. You will not operate here. The courtroom air tightened again. The judge turned to the clerk briefly, then back. This incident will be entered into the record as attempted witness intimidation. Kane's attorney stood halfway again. Your Honor, sit. He sat. The judge looked back at Kane. You were already facing substantial time. Kane's jaw clenched. The judge continued, voice calm but unyielding. Asterisk, you have now demonstrated active obstruction during sentencing. A ripple of shock passed through the room. Kane's confidence flickered. You can't, seriously? The judge raised a hand. You will not tell this court what it can or cannot do. Silence. The judge leaned forward fully now. Daniel Kane, he said, voice echoing through the chamber. Your conduct in this courtroom reflects the same pattern presented in evidence: intimidation, manipulation, disregard for authority. Kane felt it now. The shift, the loss of control. The judge picked up the sentencing document. Given the severity of the original offenses, he continued, and this additional act of obstruction in open court. The pause stretched painfully. Long asterisk. This court adds 10 additional years to your sentence. The words landed like a collapse. Gasps broke out across the gallery. Kane's face drained of color. His attorney stood in stunned silence. You can't do that, Kane said. Hoarsely. The judge met his gaze. I just did. The gavel struck, and for the first time since stepping into that courtroom, Daniel Kane looked afraid. Asterisk. Daniel Kane didn't sit down. Even after the gavel struck, even after the courtroom gasped, even after the clerk began typing the amended sentence into the record, he just stood there. 10 years, added in seconds, not negotiated, not delayed, not softened. His attorney finally grabbed his sleeve. Sit down, he whispered urgently. Kane lowered himself slowly into the chair, but his eyes never left the judge. This is excessive, he said, voice tight but controlled. You're making an emotional decision. The judge's expression did not change. No, he said calmly. I am responding to conduct. Asterisk. The prosecutor stood quietly, allowing the silence to press in on Kane. The witness remained frozen in the stand, still shaken. The judge turned slightly toward the witness. You are under the protection of this court, he said clearly. No statement made here will result in retaliation without consequence. Kane gave a faint scoff. The judge heard it. Mr. Kane, he said sharply, your reactions are precisely why this addition was necessary. Kane leaned forward. You've already secured your headline, he said quietly. You don't need theatrics. The judge's tone dropped lower. Be careful. The courtroom air thickened again. The prosecutor stepped forward. Your Honor, in light of the added sentence, the state would like to address the pattern demonstrated by the defendant. Proceed. She turned toward Kane. For years, you relied on intimidation to avoid escalation. Today, in front of this court, you repeated that pattern. Kane stared straight ahead. Your reframing tone is threat. The prosecutor didn't blink. The witness believed it was a threat. The judge interjected, and that belief was reasonable. Kane turned sharply. Reasonable? He snapped. He's cooperating to reduce his own time. The judge leaned forward. And you just proved why protection was necessary. A murmur ran through the gallery again. This time, it wasn't shock. It was realization. The prosecutor approached the evidence table. Your Honor, there is an additional matter tied to the defendant's courtroom behavior. Kane's attorney stiffened. What additional matter? The prosecutor lifted a tablet. Moments before today's hearing resumed, an anonymous message was sent to the witness's legal counsel. The courtroom grew still. Kane didn't move. The prosecutor continued. The message read, Testimony has consequences. A ripple of discomfort moved through the room. The judge's eyes slowly shifted to Kane. Are you suggesting, the defense attorney said quickly, that my client I am stating timing? The prosecutor replied. Kane finally spoke. You're reaching. The judge held up a hand. Was the source traced? Preliminary digital routing connects to an IP cluster previously associated with the defendant's corporate network. The air changed again. Kane's composure tightened visibly. That proves nothing. The judge's voice sharpened. It? Proves. Proximity. Kane leaned back. You can't hold me responsible for every message sent by every device in a network. The judge's gaze did not soften. But I can hold you responsible for patterns. The word hung heavy. Pattern, the prosecutor stepped closer. This is not isolated conduct, she said. It is consistent with the defendant's operational history. Kane's breathing deepened. You're building smoke, he said. No, the judge replied. We are observing fire. The gallery shifted again. Several spectators, who once looked confident, now looked concerned, because this was no longer just about the original charges. This was about escalation. The judge turned to the bailiff. Ensure the witness remains escorted. The bailiff nodded. Kane's attorney stood once more. Your Honor, with respect, adding 10 years based on interpretation, the judge cut him off. Based on conduct witnessed in real time. The attorney hesitated. The judge continued. Your client attempted to assert dominance over this process. Kane exhaled sharply. I exercised my right to speak. You exercised intimidation. The judge corrected. The room felt colder now. Kane's voice lowered. You're sending a message. Yes, the judge said. The honesty of it stunned the room. Kane stared at him. What message? The judge did not hesitate. That this courtroom does not bend. A pause, not to posture. Another pause. Not to influence, and finally, not to fear. Silence swallowed the space. The prosecutor returned to her table. Your Honor, the state recommends immediate remand into custody given today's developments. Kane's attorney shot up. That is unnecessary. He has complied with all pre-sentencing conditions. The judge looked at Kane carefully. You have complied when observed? he said. But you have demonstrated risk. Kane leaned forward. Again. You're overcorrecting. The judge's eyes hardened. You're underestimating. The tension between them was no longer subtle. It was direct, personal, measured. The judge reviewed the docket one final time. Daniel Kane, he said slowly, you have shown this court exactly how you operate when you believe you are still in control. Kane didn't respond. The judge's voice dropped lower. You are no longer in control. That sentence hit harder than the added years. The judge nodded toward the bailiff. Remand the defendant immediately. Gasps again. Kane's attorney protested. Your Honor, he is scheduled for formal transfer next month. That schedule has changed? The bailiff stepped forward. For the first time, Kane looked at the approaching officer, not with superiority, but calculation. His jaw tightened. This is temporary, he muttered. The judge heard it. No, he said calmly. It is consequence. The cuffs clicked around Kane's wrists. The sound echoed far louder than the gavel had. And this time, there was no whisper, no lean toward the witness, no quiet threat, just metal, and silence. The sound of the cuffs settling around. Daniel Kane's wrists did something no argument had managed to do all morning. It changed the balance of the room. He was no longer the man leaning forward, whispering threats. He was the man being held in place. The bailiff stepped slightly behind him, firm but professional. Kane didn't resist. He adjusted his shoulders as much as the restraints allowed, and looked up at the bench. You're making a mistake, he said quietly. The judge didn't respond immediately. Instead, he turned toward the prosecutor. You indicated there was additional relevance tied to the message sent before today's hearing. Yes, Your Honor. The prosecutor lifted the tablet again. Within minutes of the message being sent to the witnesses' counsel, a secondary transmission was made. Kane's attorney stiffened. To whom? He demanded. The prosecutor didn't look at him. To a private security contractor retained by one of the defendant's subsidiaries. The courtroom stirred. The judge leaned forward slightly. Content. Monarch movement. Confirm loyalty. A ripple of tension moved through the gallery. Kane's jaw tightened. That could mean anything. The prosecutor met his gaze directly. In context, it does not. Judge turned to Kane. You have already been warned. About pattern, he said. Kane shook his head slowly. This is interpretation layered on assumption. The judge's tone cooled further. No. This is conduct layered on history. The prosecutor continued. Your Honor, the state requests permission to introduce emergency documentation obtained under expedited warrant authority earlier this afternoon. Kane's attorney nearly jumped from his seat. Expedited? On what basis? On the basis of attempted interference during active sentencing proceedings. The prosecutor replied evenly. The judge nodded once. Permission granted. The prosecutor approached the clerk and handed over a printed packet. Within that warrant return, she said, we recovered a recorded internal call placed approximately 15 minutes before court resumed. Kane's expression changed, not dramatically, but noticeably. The prosecutor pressed play on a small speaker. The audio was slightly distorted, but clear enough. A voice, unmistakably Kane's, said, if he goes through with it, tighten the circle. No one talks without clearance. The recording stopped. The silence that followed felt heavier than anything before it. Kane's attorney, stood immediately. This recording is taken out of context. The judge didn't look at him. Context will be examined. Kane's voice was lower now. That was corporate damage control. The prosecutor's reply came without hesitation. Damage control for what? Kane said nothing. The judge folded his hands slowly. Asterisk, you were aware the witness intended to testify fully today. Yes, and you made calls instructing others to tighten the circle. Yes, and you see no correlation. Kane's patience finally cracked. This is how organizations function under pressure. The judge's eyes sharpened. Criminal organizations? The word hit the room like a dropped weight. Kane inhaled sharply. That's inflammatory. The prosecutor stepped forward again. Your Honor, this is not simply obstruction. It is an active attempt to maintain a system of silence. The judge's gaze never left Kane. Asterisk, Mr. Kane, he said, voice measured but cold. Do you understand that your own voice is now the most compelling evidence presented today? Kane swallowed. For the first time, he did not have a smooth response. The prosecutor continued. We believe additional charges related to obstruction and witness tampering are warranted. The courtroom erupted in whispers. The judge raised a hand. Order. The room quieted. Kane stared straight ahead, but the certainty that once defined him was gone. The judge spoke carefully. Daniel Kane, you were given the opportunity to face sentencing for your original convictions. He paused. You chose escalation. Kane's attorney tried again. Your Honor, adding charges mid-proceeding asterisk is lawful when new conduct occurs. Mid-proceeding? The judge replied sharply. The attorney sat back down slowly. The judge continued. This court cannot ignore real-time attempts to undermine justice. He turned slightly toward the prosecutor. File the supplemental charges. A visible shock passed through the gallery. Kane's breathing deepened again. You're piling on, he said quietly. The judge responded just as quietly. No, you are. That landed harder than anything else. The prosecutor gathered her materials. Your Honor, in light of the recording and message trays, we also request a full communications freeze on the defendant's known corporate channels. The defense objected instantly. Asterisk, that would destabilize hundreds of employees. The judge didn't hesitate. If those channels are being used to intimidate or coordinate silence, destabilization is necessary. Kane closed his eyes briefly. Just for a second. When he opened them, the room felt different. Because now, it wasn't just about 10 extra years. It wasn't just about sentencing. It was about unraveling. The judge leaned forward once more. Daniel Kane, he said evenly, you built an environment where fear replaced accountability. He paused. You just demonstrated that environment still exists. The bailiff adjusted position behind Kane, the judge continued. Asterisk, this court will not allow it to survive. The prosecutor added quietly, Your Honor, the witness has indicated willingness to provide additional testimony in light of today's events. The judge nodded. Noted. Kane turned his head slightly. For the first time, he looked at the witness without calculation, without threat. Just realization, because every move he had made today had strengthened the case against him. The judge lifted the gavel once more. Court is adjourned pending formal arraignment on supplemental obstruction charges. The gavel struck, and this time, it didn't feel like an ending. It felt like expansion. Asterisk as officers began escorting Kane toward the side door. He finally spoke again, quietly more to himself than anyone else. This isn't over. The judge heard. Him it is, he replied. The door closed behind Kane, and the courtroom remained seated. Longer than usual, because what they had just witnessed wasn't just sentencing, it was a man losing control, in the one place he believed he could still assert it. The courtroom reconvened the following morning under a tension that felt sharper, cleaner. Daniel Kane was brought in earlier than the public. This time, he was already in custody attire beneath a restrained jacket. The expensive tailoring was gone. The posture remained, but thinner now. The gallery was fuller. Word had spread. The judge entered without ceremony. Be seated. Kane did not look toward the witness table. He looked only at the bench. The clerk read the supplemental charge. Obstruction of justice and attempted witness tampering during active sentencing proceedings. The word sounded heavier the second time. The judge turned to Kane. How do you plead to the supplemental charge? Kane's attorney leaned toward him briefly. Kane nodded once. Not guilty. The judge studied him. Very well. The prosecutor stepped forward immediately. Your Honor? The state moves to consolidate sentencing, given the real-time nature of the conduct and the direct nexus to the underlying conviction. The defense objected. This is prejudicial acceleration. The judge responded evenly. It is procedural efficiency when misconduct occurs inside this courtroom. The objection dissolved. The prosecutor continued. Yesterday, the defendant demonstrated an active attempt to reassert control through intimidation and coordination. The recorded instruction to tighten the circle directly correlates with suppression behavior documented throughout trial. Kane stared ahead. Expression neutral. The judge turned toward the defense. Your response? Kane's attorney rose. Your Honor, emotional interpretation has replaced objective analysis. My client manages large operational networks. Language can be The judge's gaze sharpened. Language reveals intent. The attorney hesitated. The judge continued. And yesterday, intent was visible. Silence. The prosecutor lifted another document. Your Honor, additional data recovered overnight indicates follow-up attempts from associated accounts to contact secondary witnesses. A ripple of shock moved through the courtroom. Kane's eyes flicked quickly toward the prosecution table. He hadn't expected that. The prosecutor pressed on. Though these attempts were blocked due to the emergency freeze. Times. Confirm activation within 30 minutes of yesterday's adjournment. The judge's voice lowered. So the behavior persisted. Yes, Your Honor. Kane spoke for the first time. You're attributing independent actions to me. The judge met his gaze directly. They originate from systems under your authority. That doesn't make me responsible for every keystroke. The judge's reply was immediate. It makes you responsible for culture. That word struck deeper than accusation. Culture. Because culture implied design. The prosecutor nodded slightly. Your Honor, this is not a single outburst. It is a structural reaction. Kane leaned forward despite the restraints. You're criminalizing leadership. The judge's tone hardened. I am criminalizing coercion. The room fell silent again. The judge folded his hands slowly. Daniel Kane, you were given opportunity after opportunity to conduct yourself within the boundaries of this court. He paused. You chose escalation. Kane's jaw tightened. The judge continued. You demonstrated not remorse, but persistence. The defense attempted one final push. Your Honor, Adding time at this stage risks disproportionate sentencing. The judge looked down briefly at the statutory guidelines, then back up. Obstruction during judicial proceedings warrants enhancement. He looked at Kane again. And intimidation warrants deterrence. The prosecutor stepped forward for final recommendation. The state requests an additional consecutive 10-year enhancement. The gallery reacted audibly. Kane's attorney nearly dropped his file. 20 additional years total. He whispered to Kane. Kane didn't answer, because he understood something now. This wasn't about negotiation anymore. The judge spoke slowly. Daniel Kane, you built your operations on fear. A pause. You attempted to bring that fear here. Another pause. This court will not operate inside it. The silence was suffocating. The judge lifted the formal sentencing document for the supplemental conviction of obstruction and attempted witness tampering. This court imposes an additional 10-year consecutive sentence. Gasps the defense. Attorney closed his eyes. Kane didn't move, but his breathing changed. The judge wasn't finished. In addition, the court orders permanent prohibition from holding executive authority in any corporate entity upon release. That one stunned even the prosecutor. Kane finally reacted. You can't strip future rights based on, I can impose conditions tied to demonstrated abuse of authority. The judge replied. The room felt like it had shifted permanently, because this wasn't just prison time now. It was structural dismantling. The judge leaned forward one final time. Daniel Kane, he said quietly, you believed power was control. A pause. You confused influence with immunity. Kane stared back at him. The judge's final words were measured. This sentence ensures neither returns with you. He raised the gavel. And let this be understood clearly. Intimidation inside this courtroom does not extend time by accident. The gavel struck. It extends it by design. The echo lingered. 20 additional years. Authorities stripped. Communications frozen. Corporate network under audit. As officers stepped forward to escort Kane away, there was no whisper, no smirk, no leaning toward a witness, only the heavy rhythm of chains and footsteps. At the door, Kane paused. Not dramatically, just long enough to look back once. The judge was already reviewing paperwork, not watching him. Because the performance was over, and the control he once relied on had ended. The moment he tried to use it in the wrong room. The door shut, and this time no one believed he was coming back stronger.